And I will just go ahead and let the court know, I do have several people this morning, this afternoon that will need a breakout room, and Mr. Williams is one.
Okay. Tell me the people that you're gonna need a breakout room to speak with people.
No, Your Honor, I'm saying it's to discuss their matter.
Right. You gotta speak with forward. Who do you need to speak with, Miss St. Lex?
I'm sorry, Judge, you went out.
Who do you need to speak with? Can you hear me?
Yes, so I've spoken with everybody, but to discuss their case with the court, and I would need a breakout room because I can't discuss certain things in open court for HIPAA reasons.
So you're gonna need breakout room.
Judge, you're not.
You have a problem with your audio, Judge. I don't want you to keep talking and we can't hear you. It's like you're going in and out. So I don't know if you need to adjust your auto.
Can you hear me better now?
That's great.
Is that better?
Yes.
Okay, so we need to discuss Mr. Williams in a breakout room.
Yes, Your Honor.
Okay, so if we can put Ms. St. Flex, who's presenting for the state, Ms. Herring?
Yes, Your Honor.
Ms. Herring, Ms. Bridgewater, anyone else need to go into the breakout room?
Judge, I think she said that they had more than him.
Okay, and which other cases are you gonna need to go into a breakout room with, Ms. St. Flex?
Let's see, Mr. Magyar and not Mr. Hoffman.
Give me the numbers, please.
Judge, if I could just have a second to look at my calendar to get the exact numbers, but I can go ahead and move forward with him.
I would like to do all the breakout rooms at one time so that we don't have
Okay.
to keep going in and out of breakout rooms.
Got it, understood.
So I know one is number 11, is that right?
That's correct, Judge.
The next person is Mr. Curtis Hines. He is position eight on the calendar.
Okay. 8, 11, and add on 3. So if the ASGs on those matters will also accompany us into the breakout rooms, Miss Helena Allen also sure wants to be in the breakout room. Is one of those cases yours, Ms. Todd?
Yes, 2 of them are, Your Honor.
All right, good afternoon. So if you can put us into a breakout room, please.
For everybody who's logging in under iPhones, iPhone 2, Motorola iPhones, can you please adjust your name on your phone so we know who you are in the court, just in case we have to address you. So if you do not know how to change your name, please DM me, Fulton County State Court, with your name, and I will change it for you. Thank you. Please double check the ones that DM me about the iPhone. Make sure I got the correct name underneath the correct iPhone area, because both of y'all had iPhone and it was hard to be identified who you were. The young lady who's on the motor career, we will not be able to talk to you because your auto is not connected to the Zoom. So you may have to log out and log back on and select allow, or you can have your auto on. You only can see the video at this time. So if you have to speak, we won't be able to hear you. So you may want to log back out and connect with your auto. I'm talking to you, Miss Moda. If you can hear me, I won't be able to hear you because your mic is not connected.
Okay, so we are back. Let me see. Let me sound for Miss Stevens. Is Miss Zakaria Stevens present in the Joseph Williams case?
Yes,
Yes. Good afternoon, Miss Stevens. Can you activate your camera for me?
my camera don't work.
Okay, and you are Zakaria Stevens, is that right?
Yes,
And can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court would be the truth, the whole truth, and nothing but the truth?
yes,
Okay, Ms. Stevens, it's my understanding that you would like continued contact with Mr. Williams, is that right?
yes.
Are you afraid of him?
No, ma'am. No, sir.
Do you do you all live together at the present time?
At the present time, yes.
Okay. Has this ever happened before?
No.
Okay. We've had a discussion on Mr. Williams, on Mr. Williams's case with his counsel, and once he gets situated there. Okay,
Judge froze up. Judge, you froze up.
is he situated?
No, this is Katrina speaking. I was letting you know you froze up.
Oh, I wasn't saying anything.
Oh.
All right. Mr. Williams, I've had a discussion with your counsel. It's going to be a $5,000 signature bond through the jail, no further violent contact with Ms. Stevens, and no drugs, alcohol, or weapons while out on bond. I'm going to give you the opportunity to get out, but you're going to have to make sure to show up for your next court hearing, okay?
Okay, but when would I be able to talk to y'all about personal information about this case?
You'll be able to speak with your attorney before your next court hearing, sir. Okay, so you'll be able to speak with her before you come back to court again, if that's what you like to do. Okay.
All right, do I need to bring the evidence too?
Let's talk with her about that. Okay.
All right.
All right.
Your
so-
Honor, I'm sorry
Yes.
to interrupt very briefly. Did Miss Williams, who we cannot see, I kind of have a problem with that. I have to say on the record, I don't know that that's appropriate at this point, but the defense counsel's representation previously was that they are no longer living together, and that is why no violent contact is appropriate, because they share custody of a child. But she just said on the phone that they currently live together. This
What?
incident happened in September.
When did I say that we had a child?
Defense counsel said that they are currently co-parenting, and that's why they need to have contact,
What?
and that they no longer live together.
That's the note that I have.
That we do.
So I think that the contact issue should perhaps be revisited. That's what the state's request should be at this time, since there's a conflict in the information.
Okay. Let's see, Ms. Stevens. Ms. Stevens.
Yeah.
Do you have any children with Mr. Williams?
No.
This incident happened on September 5th of this year. Have you all been together since September 5th?
Yes.
Have there been any incidents between you since September 5th?
No.
Was there any previous incidents between you before September 5th of this year?
No.
Okay, as such, my ruling is going to stand as far as a no further violent contact with Ms. Stevens. Okay? All right, so good luck to you, Mr. Williams. Courtroom 2, we've also, I want to see if you have we've also done 200 people while we were in the breakout. Can we next go to position number 8, Curtis Hines?
Come on, Mr. Hines. Thank you.
Good afternoon, Mr. Hines. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 008017E with criminal trespass. We've had the opportunity to have a discussion on your case, Mr. Hines. Your bond is going to be a $3,000 signature bond through the jail. No further contact with Ms. Dawson. Stay away from 2980 Jonesboro Road, and no drugs, alcohol, or weapons while out on bond. Okay, so I'm going to let you sign your own bond to get out, but you're going to have to make sure that you come back to court for your next hearing. Okay.
Yes, sir.
All right. Good luck to you, Mr. Hines.
Yes, sir.
Okay. You got
Can we next go to position number 11, Mr. Maggie?
here, Mr. Hines.
Yes, sir.
Come on, sir.
Good afternoon, Mr. Magyarkin. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video? Can you hear me, Mr. Magyar?
No, I do not.
Okay, well, we're just gonna have to, counsel, what's its? Counsel? Ms. St. Flex?
Mr. Magyar, the court is asking if you agree that your bond hearing can be on video, because if not, you're gonna have to be reset for another court date. Are you okay with us moving forward with your case on video today? Because if not, we will need to reset your case. So is that it? You have to say a yes or no.
Well, right now, yes.
Okay.
We have an opportunity to discuss your case. Also, Mr. Magyar, for the simple assault, it's going to be $1,000 good bond. For the criminal trespass, it's going to be a $500 good bond, making for a total of a $1,500 good bond. There's going to be a social worker visit to discuss living arrangements, no further contact with Amanda Mayar. At this time, stay away from the 225 Worthington Hills Trace address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, sir.
Thank you.
All right, you can have the seat.
Yes.
Position 2, add-on, Mr. Hodge.
That'll be mine for the state, Your Honor.
Okay. Good afternoon, Mr. Hodge. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're doing by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 008025C with willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
It's third arrest. First arrest was back in March. Felony theft by taking possession of a pistol or revolver by person under 18 years of age. Misdemeanor possession of marijuana. He was arrested in October. Possession of a pistol by person under age. 22 CP 207580. That's it.
Ms. Herring?
That's the information I have as well, Your Honor. He has 3 arrests all this year, 1 in March, October, and November, 2 involving firearms. As to this case, the facts are a state trooper was patrolling on Interstate 20, noticed a car speeding, clocked it at 107 miles per hour.
Good afternoon, Your Honor.
Sorry.
Go ahead. Go ahead, Ms. Herring.
The officer, the state trooper initiated a traffic stop, at which point the car sped away.
I don't know what the issue is with the.
Ms. McLeod, I think that's you, and we're right in the middle of Ms. Herring's presentation. Ms. McLeod?
Yes, Your Honor.
Is this your client?
Yes, it is my
Okay.
client.
Yes, Ms. Herring's in the middle of her presentation at the present time, so I'm going to allow her to continue.
Yes, Your Honor.
Go ahead.
I was
Ms. Herring.
having a bit of an issue.
Oh, okay.
Yes.
Yes, Your Honor. So the officer attempted to initiate a traffic stop. The car fled. There was a chase. That chase ended on Forsyth Street in Atlanta in a collision with 2 other vehicles. 2 occupants of those other 2 cars were injured. There were 4 occupants in this car. One of them was Mr. Hosh, who was a passenger, not the driver. He and all the other occupants fled from the officers on foot. Trooper Young gave chase and apprehended Mr. Hosh and charged him with misdemeanor obstruction. State's recommendation of bond, since he has 3 arrests all in the same year and he's already on bond, 22 CP 207580 is $5,000 surety bond with the curfew. He is 18 years old. He just turned 18 this month. And he's been in a lot of trouble in the last 12 months. So we'd be asking for a 9 p.m. to 6 a.m. curfew. except for school or work, and any other conditions that the court would deem appropriate on drugs, alcohol, firearms.
Ms. McLeod?
Yes, Your Honor, my client is 18 years old. My understanding is that he was just a passenger in the vehicle that was stopped by the police. He said that he wasn't doing anything. The driver ran away from the police and he just happened to be in the car. And when the car stopped, everybody fled because nobody wanted to be arrested. He tells me that he is not working, Your Honor, although he does have his GED, he tells me, and he lives at home with his dad. I would ask the court to take into consideration that he's only 18 years old. Your Honor, I know he has been arrested a couple of times before. He is not employed, of course, so he's not in a position to post any significant bond. But I think maybe his father may be able to help him if the bond is a little less.
And Your Honor, further condition, he has a co-defendant on this case. It's also on the calendar, Mr. Kawan Brown. And I'd also like to ask the court order them to stay away from each other for reasons I'll get into when we get to Mr. Brown.
All right, anything further, counsel?
Nothing further, Your Honor.
All right, it's going to be $1,000 good bond. No further contact with Mr. Kawan Brown. A curfew of 9 p.m. to 6 a.m. except for school activities or work activities. No drugs, alcohol, or weapons while out on bond. All right,
Thank you.
Mr. Hodge.
Yes, sir. Thank you.
Next is condition 1, add-on, Mr. Brown.
Good afternoon, Mr. Brown. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir.
Thank you. You've been charged in case 22 CR 008026F with willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
His fourth adult arrest. Last arrest was in April for trespass, entering auto with the intent to commit theft. That was out of car, appears to be open. Got an open case in Fulton, 21 CP 204490. Unlawful for person to associate with street gang and theft by receiving. I got another open case, 21 CP 204492. Hijacking a motor vehicle, reckless conduct, and robbery. That's it. His first cycle was a juvie arrest. Oh, that theft by taking on robbery was dismissed in 2021, just so you know.
Anything to add to the facts, Ms. Herring, that you haven't already told the court?
No, Your Honor, just that the only difference is their history. The facts are the same.
Okay, what's your recommendation?
It was the same as for Mr. Hosh, 5,000 surety bond with the curfew from 9 p.m. to 6 a.m. He's also 18. He'll be 19 in January. But he also has open case, open major felony case that hasn't been indicted. And his last arrest was, I believe, in April of this year in Cobb County, and he's an open case out there too for entering auto. And so we would ask for a surety bond and the curfew, no drugs, alcohol, or weapons.
Okay, thank you. Ms. Gant?
Thank you, Your Honor. Mr. Kawan Brown is 18 years old. He has been in the Atlanta, Georgia area his entire life. He does have family here. Mr. Brown earned a GED, and at this time he is unemployed, Your Honor. He is presumed innocent in this case and any open cases. We heard about prior arrests, but in open cases, he is presumed innocent in those open cases. And what we have here is an 18-year-old who does not have any convictions. I am requesting a signature bond on Mr. Brown's behalf. He doesn't have the means to pay anything toward bond, Your Honor, and we are unopposed to the stay away for Mr. Hosh. Thank you, Your Honor.
All right, it's gonna be a $2,000 good bond. No further contact with Mr. Hosh. 9 p.m. to 6 a.m. curfew. Only exceptions are for school and for work. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Brown.
Thank you, Your Honor.
Position 12, Singleton.
Good afternoon, Mr. Singleton. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Mr. Singleton, if that's courtroom 2, could you mute while I? Thank you. Mr. Singleton, you've been charged in case 22 CR 008022H with criminal trespass and giving false information to law enforcement officer. Is there a history, Mr. Howard?
This is 5th arrest. Last arrest was back in March for simple battery. That's open in state court. Hold on. Yes, for simple assault. It just says bind over. Before that was August 2021, simple assault. 2021, July misdemeanor possession of marijuana, and another July arrest for shoplifting. So this is 5th arrest. The booking sheet says Macon, Georgia as an address, but I mean, he wouldn't recommend anywhere because of the open case. But just FYI.
Thank you. Ms. Todd?
Thank you, Your Honor. At approximately 7 o'clock last night, the defendant was reported by Georgia Tech Police as a suspicious person inside of a building on their campus that was off limits to the public at the time of his entry. When officers arrived, they confirmed with the defendant that he was not an employee nor a student of Georgia Tech. The defendant admitted that he followed someone into the building after they had swiped their access card, despite there being a sign outside the door that stated that access cards were required from 6 p.m. to 7 a.m. Additionally, when the officers asked for the defendant's name, he provided them the name of Aiden Jordan, among other names. After approximately 30 minutes of searching GCIC and NCIC, officers were able to properly identify the defendant as Justin Singleton. We are asking for a $1,000 surety bond on the criminal trespass, as well as a $1,000 surety bond for giving false information to law enforcement. While he does not have the extensive history, he does have that open case. We are asking for a stay away from Georgia Tech, and we are also asking for no drugs, alcohol, or weapons while on bond.
Okay. Who's representing Mr. Singleton?
I am, Your Honor.
Okay, you can proceed, Ms. McLeod.
Your Honor, my client is 22 years old. He tells me that he is currently homeless. He doesn't have anywhere to live. He doesn't have any supporting relatives. He does have a sister that he is in touch with. He has not been able to work for a long time, Your Honor, because he has some issues which do not allow him to work. He only has a 10th grade education. He denies that he did anything wrong in that particular encounter, Your Honor. He really doesn't understand what happened based on what he tells me. He just feels like he just got arrested for no real reason. He doesn't have anyone to bond him out, as I said, Your Honor. He is homeless. So if he does not receive a signature bond, he's just going to sit in jail. That really is the bottom line.
Okay. Mr. Howard, is the open simple assault in Fulton?
Yes.
Okay. So thank you. It's going to be a $500 good bond on each charge, making it for $1,000 good bond total. Ms. McLeod, I would like you to have a social worker visit with him regarding housing. When I see him back, if he's still in custody at the SAP calendar in 2 weeks, I'd like to see if we can consolidate those two cases that he has here in Fulton County. In this case, he's to stay away from Georgia Tech and also have no drugs, alcohol, or weapons while out on bond. So, Ms. McLeod?
Yes, I was going to say, Your Honor, I am not able to initiate social worker services for my clients. My understanding is that it has to be initiated through the public defender's office. That was what I was told in the past when I tried to initiate services to my clients.
Your Honor, I apologize for interrupting. I'm happy to enter the consult.
Thank you, Ms. Gann. I appreciate it. So if you'll enter that for him, and I'd like to address both these cases if he's still in custody in 2 weeks. Okay, and once I get a report from the social worker. All right, good luck, Mr. Singleton.
Thank you, Your Honor.
10, Mr. Love.
Good afternoon, Mr. Love. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Love, you've been charged in case 22 CR 008020D with 2 counts of simple battery. Is there a history, Mr. Howard?
24 total. It's like the last arrest was in 2012. Burglary, theft by taking out of Forsyth. On probation for that, out of Clayton County. 2012, they gave him 7 years to serve and 13 years probation. Also he's on probation in Forsyth for theft by taking and RICO Act. 2013, they gave him 8 years to serve, 20 years probated. That's pretty much it.
Okay.
And recent.
Ms. Todd?
Thank you, Your Honor. What started as a verbal dispute between the defendant and his friend, Miss Frances Ray, that's Frances, Ray, common spelling, was escalated when the defendant stood behind her and wrapped his hands around her neck. Miss Ray's minor, I believe, granddaughter, whose initials are DL, attempted to stop the defendant, but he shoved her to the ground and continued his attack on Miss Ray. We did have access to jail calls, Your Honor, between the victim and the defendant, in which you can hear them arguing as to the facts that he choked her and pushed her baby. As pretrial stated, there is a significant criminal history here, including the fact that he is on probation now. And we also show that he has an open case out of Noonan for possession. With this history, he also has a significant history of violence, including an arrest, 3 arrests for battery. We are asking for a $2,000 surety bond for each count of simple battery, which would be a total of a $4,000 surety bond, a no further contact with Miss Frances Ray, a stay away from her address, which is a 4885 Lockerbie Drive, that's LOCHERBY. We are also asking for 1 day of anger awareness and no drugs, alcohol, or weapons.
Ms. McLeod?
Yes, Your Honor. My client is 52 years old. He is a native of Atlanta. I have spoken to Miss Ray, and she tells me that they have known each other since 1999 and have lived together on and off. She says this is the first something like that ever happened between them. She tells me that she would prefer no further contact, even though they have known each other so long. But she did say that she thought he was a good person. And she also said that sometimes, she doesn't know what set him off on this particular occasion, but to quote her, it could have been her mouth. So she does have a very sharp tongue. That's what she told me, Your Honor. But she said this is the first time something like that has ever happened. She and I had a conversation for about half an hour, speaking about him. She says she really wants him to get out of jail because he does have a job and she would like to see him out. My client does have 3 adult children, Your Honor, and he does have some grandchildren, he tells me also, and he is gainfully employed right now doing construction and truck washing, he tells me, Your Honor. And I know he does have some history, but it is pretty remote. I think the last time he was arrested was in 2012. And since that, he has not been in any trouble. I noticed that the prosecutor talked about his history of arrests, Your Honor, but arrests were not convictions. And I don't believe he's been convicted of anything violent. Nothing further, Your Honor.
Okay, so for the first simple battery, it's going to be $1,000 good bond. For the second simple battery, a $500 good bond, making for a total of a $1,500 good bond. No further contact with Ms. Ray. Stay away from the Lockerbie Drive address, and no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Love.
Thank you, Your Honor.
Position 9, Hoffman.
Good afternoon, Mr. Hoffman. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, ma'am.
Sir.
Thank you.
Sir.
Mr. Hoffman.
Sir.
Oh, I'm sorry, go ahead.
All right, Mr. Hoffman, you've been charged in case 22 CR 008019D with driving under the influence of alcohol less safe, improper right turn, driving on the wrong side of the road, disorderly conduct, terroristic threats, simple assault, and 2 additional counts of terroristic threats. Is there a history, Mr. Howard?
26 total between North Carolina and California. Last arrest was 2017, driving while impaired. That was in North Carolina. Before that was, hold on. All right, he was arrested in 1990 in Georgia for DUI that was dismissed. 1994 out of California on a bench warrant. So outside of 2017, everything else is in the 90s, 80s, and 70s.
Ms. Todd?
Thank you, Your Honor. The defendant caused his vehicle to collide with the vehicle of a Terrell Johnston, Terrell common spelling, Johnston common spelling, on Old Alabama Road and Riverside Road when he improperly made a right turn, drove on the wrong side of the road, and collided with the front of his vehicle. This incident was caught on Mr. Johnston's dash cam video that was reviewed by police. Upon arrival, officers Justin D'Agostino, that's apostrophe Agostino, and Officer Samuel Carter spoke to the victim and then went to speak to the defendant. When asked what happened, the defendant stated that nothing happened, despite the fact that there was damage to the vehicles and the positioning of defendant's vehicle. Officers asked the defendant if he had been drinking. The defendant stated that he had not been drinking, despite the fact that officers could see that his eyes were both watery and bloodshot and that his speech was slurred. When asked again if he had been drinking, defendant's response to the police officers was "suck my," and I will omit that word. Then the defendant stated in the presence of both officers and Mr. Johnson that he was going to F them up. After obtaining the defendant's ID, Officer D'Agostino returned to his vehicle to check GCIC. While he was in his vehicle, Mr. Johnston ran to the officer's vehicle and started pointing at defendant's vehicle. When the officer returned, Officer Carter informed him that the defendant started to reach for something in his driver's side door. When Officer Carter asked what the defendant was reaching for, he said a gun. And the officers did recover a Springfield Hellcat from the driver's side door. We are asking for a $500 surety bond on each of the counts, making that a total, I believe, if my math is correct, I think it is a $7,000 surety bond. As pretrial stated, this is not his first DUI. We are also asking for no drugs, alcohol, or weapons. Additionally, 1 day of anger awareness and no further contact with Mr. Johnston or either officer.
I'm sorry, Ms. Todd, tell me again how much.
We're looking for
on each.
Sorry, Your Honor.
No, you're fine. Just you want 500 for which charges?
It will be 500 for each of the 8 counts. So that would be a total, and my math was completely wrong. It would be a total of a $4,000 surety bond.
Okay, all right, that's what, that's what I came up with, but I didn't know if I misheard you.
I went to law school. I'm not a CPA.
All right, let's see, who's representing, oh, Ms. St. Flex?
Yes, Judge. Mr. Hoffman was recommended for pretrial. It's my understanding from speaking with him that on the date of the alleged incident, he was given information that he was he was positive for cancer, prostate cancer to be specific. He's supposed to start his chemotherapy treatments on this Thursday at the VA hospital. He was in the US Army in the 70s. He is a Vietnam vet. During the I've spoken with him about, you know, his possibility of having a gun on his possession in the future, and that he won't be able to have one while this case is pending. So we have no objection to no possession of guns. But I think as mentioned, this was an isolated incident. 5 years ago, I did not hear a conviction on that charge. I think it's my understanding that case was not a conviction. If I'm wrong about that, I don't believe I heard a conviction. I did speak with him about if he's ever been in a treatment center. He said 5 years ago when he got this other case in North Carolina, he was in a treatment center for weeks. He lived there. He's been clean for 5 years, the last 5 years, which is why we see no record or no incidents of anything from him. And then unfortunately on this date, he received his diagnosis and he can't really give much information about the rest of the day. I spoke to him about his financial circumstances and he is not at this time able to afford to bond out through a surety bond. Neither is his family because of his health condition. He is receiving disability. He was already receiving disability, but now he just is unable to work completely. So we would just be asking that I think I did speak to him because I know chemotherapy treatments can be very much so taxing. And so although he is recommended for pretrial, I did ask him about if he thought he was going to be able to report once a month to pretrial. He thinks at this time he is possibly going to be able to do that. So if the court were to order that he's released through pretrial, we would have no objection. But we would prefer, because he hasn't started the treatments yet, and so I don't know if he understands the significance of them, we prefer that he gets a signature bond through the jail. And that amount for each account through a pretrial bond or a signature bond, we would leave to the court.
Okay, so for each count, it's going to be a $500 good bond through the jail, making for a total of a $4,000, I'm sorry, a $5,000 signature bond through the jail, which makes it a total of a $4,000 signature bond through the jail, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Hoffman.
Sorry. That's a signature bond I can sign to go to the hospital.
Yes, sir, you can do that. Good luck to you.
And then I'll provide you with whatever you need as far as my treatment goes, and I will do whatever the court says. This was a bad judgment on my side. Thank you.
Thank you, sir. Good luck to you.
Yes, sir.
Position 6, Green.
Well, where do you want me to go? Just sit.
Good afternoon, Mr. Green. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Mr. Green, you've been charged in case 22 CR 008013A with battery family violence. Is there a history, Mr. Howard?
This 10th arrest. Last was 2017 probation. 2015 probation. 2011 conviction for forgery in the first degree. That's where the probation came from. And they gave him 10 years probation for that back in 2011. 2009 shoplifting conviction. 2008 cruelty in the first battery. Those were dismissed. And before that was 02, giving false name conviction.
Ms. Todd?
Thank you, Your Honor. This incident started as a verbal altercation between the defendant and his on-again, off-again girlfriend, Miss Taya Williams. That's T-Y-A, Williams, common spelling. The incident was escalated when the defendant punched Miss Williams in the face, leaving a laceration under her right eye. While the defendant does have 2 previous arrests for violent offenses, as well as 2 probation violations on his record, we do sense a risk of reoffense here. We also do sense a risk of intimidation of the witness, possibly. We have not been able to contact Miss Williams at this point, but as of the date of the incident, they were in an on-again, off-again relationship. So we do believe there's the potential that it may be on again. We don't know. We are asking for a $3,000 surety bond. We are also asking for no further contact, 1 day anger awareness, as well as no drugs, alcohol, or weapons.
I'm
Your
sorry,
Honor,
Ms. Todd, did you give me the stay away address?
We did not, Your Honor. We're not asking for a stay away. The incident did happen at a location that Miss Williams was not living at. And I do believe it was the defendant's sister's address.
Okay, thank you. Ms. McLeod?
yes, Your Honor. My client is 47 years old. This incident happened several years ago, that is my understanding. My client tells me that he and Miss Taya have not been in contact with each other for several years now. He denies that he hit her or he did anything to physically harm her. They are not in contact, as I said, Your Honor. He doesn't know where she is. He hasn't spoken to her in a few years. My client is employed, Your Honor, but he doesn't have any money to make bond. And I would ask the court, given how remote his history is, I know the prosecution mentioned that he had been arrested, but he does not have any convictions or any kind of violence, Your Honor. I would ask the court to consider giving him a signature bond, considering how long ago this incident happened and his allegations that he's no longer in touch with the alleged victim. The state wasn't even able to get in touch with her themselves, and he had no contact information for her, Your Honor. Nothing further.
It's going to be a $3,000 signature bond through pretrial, 1 day anger awareness, no further contact with Ms. Williams, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
You're welcome. Good luck to you, Mr. Gray.
Position 1, Brown.
Good afternoon, Mr. Brown. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're doing by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Brown, you've been charged in case 22 CR 008012Y with criminal trespass and damage to property. Is there a history, Mr. Howard?
His 4th arrest. Last arrest was in 2021. It was for misdemeanor terrorist threats. He's on probation for that. It's 21 CR 003-745A as an apple. Before that was 2019, possession of drug-related objects, 2 counts. They were NOD 2016 out of South Carolina. Says receiving goods. I guess theft by receiving conviction. That's it.
Good afternoon, Ms. Sorry. Is this your case?
Good afternoon, Your Honor. Yes, it is. Your Honor, this incident took place at 92 Holcomb Bridge in Roswell. Officers responded to the incident location regarding a dispute involving the defendant and the victim, whose name is Tiara. That's Tiara. Last name Mitchell, common spelling. When they arrived, they spoke with the victim, who stated that she and the defendant were in an argument, and the defendant took her property and threw it into the parking lot. The defendant did admit to the officer he threw her items out. The state is amenable to a signature bond through pretrial. We're asking for $3,500. No contact with the victim. stay away, 1-day anger awareness, and no drugs, alcohol, or weapons.
Ms. Gant?
Thank you, Your Honor. We are unopposed to the signature bond, $3,500 SOB through pretrial services. We are opposed to the stay away. Mr. Brown informs me that that is in fact his residence and that the complaining witness, Ms. Tiara Mitchell, no longer lives there. About Mr. Brown, he is 29 years old. He has been in the Atlanta, Georgia area for 5 years. He does have family here, including an aunt and an uncle. He completed high school and also studied liberal arts in college. He is unemployed at this time, Your Honor. He is physically disabled. He just began receiving payments for his disability, very small payments such that he qualifies for the services of the Public Defender's Office, Your Honor. He does not have the means to pay anything toward bond. He is presumed innocent, Your Honor. And again, we are unopposed to the signature bond as proposed, and we are opposed to the stay away. And we are unopposed to no contact as well. Thank you, Your Honor.
Okay, it's going to be a $3,000 signature bond through the jail. No further contact with Ms. Mitchell. Out of an abundance of caution, he can go back to that 92 Holcomb Bridge Road address with a one-time escort by law enforcement. If Ms. Mitchell is not there, then he can stay there. If she is there, then he is going to have to find some other place to reside. No drugs, alcohol, or weapons while out on bond. Ms. Gant, your client had his hand up.
Mr. Brown, I'm happy to give you a call. You receive a signature bond, you'll be able to sign yourself out and you can return with police officers to confirm what you advised me about Ms. Mitchell no longer being there.
Okay, I was just because
I don't want you to make any statements about your case. I'm happy to give you a call if you'd like.
Okay.
All right, thank you. Courtroom 2, please hold him.
Position 13, Wilcox.
Good afternoon, Mr. Wilcox. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Wilcox, you've been charged in case 22 CR 008023G with battery, family violence, 2 counts and 1 count of cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
His second arrest. He was arrested last week in Cobb County, sale of marijuana, 2 counts. 1 count possession of a knife or a firearm during a commission. That's open. That's it.
Ms. Todd?
Thank you, Your Honor. What started as a verbal altercation between the defendant and his girlfriend, Miss Darnecia Dixon, that's D-A-R-N-E-C-I-A, Dixon, common spelling, was escalated when the defendant punched her in the back of the head while she was holding their less than a month-old child at the time. The defendant then snatched the child out of her mother's arms. The child's initials are D.W., causing, as he snatched her, the child scratched Miss Dixon across the chest. Because by being snatched by her father, the 1-month-old baby suffered a busted lip on the right side of her mouth. We are concerned in this case, Your Honor, of the significant risk of intimidation of this witness. The defendant and Ms. Dixon are still in a relationship. He is the father of her child. The two do live together at 2600 Fox Hallway. Our office was able to review jail calls between the victim and the defendant. One of the calls, the victim stated that I want to come to court to tell them what you said. Implying that she has already been coached into protecting him. When our office spoke to the victim, she informed us that it wasn't even her that called the police. It was her mother. Out of fear for her daughter and granddaughter's safety, she's the one who called. We are asking for a $3,000 surety bond on the first count of family violence. We are asking for a $1,500 surety bond on the cruelty to children and a $3,000 surety bond on the second count of battery family violence. We are also asking for a no further contact with Miss Darnecia Dixon. We are asking for a stay away from the 2600 Fox Hallway address. 1 day of anger awareness, and no drugs, alcohol, or weapons while on bond.
Ms. St. Flex?
Yes, Your Honor. Just in response to the jail calls, we haven't received anything. We haven't received any recordings. We would prefer those sent over. I think there was a sentence taken out of it as far as suggesting that intimidation was going to occur. I want to come to court to tell them what you said. We have no information of the context or what was said before or after that statement. So we think it's improper for the prosecution to be presenting information and evidence about jail calls or specificities about what's said between my client or someone else, and we don't have access to that information. So we just want to say that. As far as the address of the incident, the 445 Markham Street, I'm not sure if I heard a stay away, but that is his sister's address. So we would ask that there's no stay away from that address. The address of Mr. Wilcox is a 2190 Verbena Street Southwest. We would just ask if he needs to go to that address for any reason, if he could be escorted by a police officer for the 445, and just to ensure that she's not there. But it's my understanding again that that's his sister's address. As far as Mr. Wilcox's ties to the community, he's lived in Georgia his whole life. He has other family that lives here, his grandparents. He works for Cookout, Your Honor. He was working for Cookout before he was arrested. He's had that job for 7 months. So he wasn't making much money to afford the bond that was requested by the prosecution. But he is looking forward to getting back to that job if he's able to be released. He's completed high school from my conversation with him. And as far as the open felony case that he has, it's my understanding that he expects that case to be resolved once they figure out that he is not involved in what was taking place. Because of the situation and we have not had any contact with the alleged victim, we have no objection to no further contact. Again, we're just saying no stay away. I do believe what was stated was that the baby had a busted lip, but I just want to clarify the information that I seen was that the alleged victim had a busted lip and not the actual 10-month-old baby in this situation. We are requesting a signature bond, but if the court is not inclined to give a signature bond based on the information presented, we would request that he's given a $250 surety bond for each charge.
Okay, the stay away they requested, Ms. St. Flex, was from a 2600 Fox Hallway address. Do you have any objection to a stay away from that address? I don't know.
No, Your Honor, that's the address I have where she lives. So no, we have no objection.
All right, so for each count of battery, family violence, it's going to be $1,000 good bond. For the cruelty to children, a $500 good bond, makes it a total of a $2,500 good bond. No further contact with Ms. Dixon, stay away from the Fox Hallway address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Wilcox.
Thank you, Your Honor.
You're welcome.
Judge, we're completed here in courtroom 2.
Okay, so the rest of the cases are at the South Annex this afternoon?
Also courtroom 3.
In courtroom 3? Okay, thank you. Have a good afternoon.
Thank you. You too, Judge. Thanks.
Thank you. Courtroom 3, who do we have?
Judge, I have position number 7, please.
Okay. This is Ms. Hamilton.
Yes.
Good afternoon, Ms. Hamilton. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Hamilton, you've been charged in case 22 CR 008014G with simple battery. It's my understanding from pretrial that this is Ms. Hamilton's first arrest. Ms. Sari?
Yes, Your Honor. This position is a co-defendant case with position 2. And regarding the facts, this incident took place at the state capitol building at 2 Peachtree Street, Northwest in Atlanta. We don't have the full report yet, but per the warrant, The defendant and the co-defendant went up to the victim's job and fought her. The victim in this case, her name is Gayla Hamilton. That's Gala, last name common spelling. And the victim did sustain lacerations to her eye. For Ms. Hamilton, the state's recommendation is a $2,000 surety bond, no contact with the victim, no contact with the co-defendant, and to stay away 1 day anger awareness, no drugs, alcohol, or weapons.
Who is Gayla Hamilton to Apri Hamilton?
I have down that she's her aunt, but I'll defer to defense.
Your Honor, she is her aunt, but has had custody of her and has been acting as her mom for some time since she was a young child. My client is only 17 years old, Your Honor. She has already graduated high school and she is working. She alleges that her aunt, stroke mom, is very abusive and had neglected her. She was forced to return to live recently, I think in October, she told me, with her birth mom and her birth sister. She said she had gone to her aunt, stroke mom's place of work because she wanted to talk to her about the abuse and wanted to let her know that she was going to file charges against her for what she thought was her abusive behavior. And she tells me that was when her aunt, stroke mom, attacked her. And she believes her aunt was also arrested, but she is not sure. My client has no history at all, Your Honor. She is, as I said, 17 years old, has already graduated high school, is already working, Your Honor. There obviously some history between the parties, which, of course, I'm unable to go into here, but this is what my client tells me, that she just went up there to talk with her when she attacked her.
Does she have a place to live, Ms. McLeod?
Yes, Your Honor. She tells me she can live with her sister, which is where she has been living since October.
What's her sister's name, and do you know how old her sister is?
I do know her sister's name, Your Honor. Let me just pull it up from my notes, just a moment. Her sister is Kimberly Hamilton, Your Honor, and her sister is 22, I believe she said. She also says that her mom, Leonora Hamilton, also lives at the sister's address. And I have contact information for both of those people.
Okay. Well, is Miss Lenora Hamilton willing to sign her daughter out?
I believe she would be, Your Honor. I didn't get a chance to speak to her yet. But just based on what my client tells me, it sounds as if she would be prepared to sign her out, or her older sister would be.
Your client has her hand up. She might want to clarify something.
Go ahead, Ms. Hamilton. Is this about you, the contact?
Yeah, so you got it mixed up. Kimberly is my mother and Lenora is my sister.
Oh, I'm sorry. I put them the other way around. And how old did you say your sister was? Was she 22?
No, my sister is 19.
Oh, she's 19.
The sister that I live with, she's 30, 37, 38.
Oh, she's 37, the one you live with. I don't know where 22 came into this conversation. Must have been another sister. So your sister that you live with is 37.
Okay. Yes, 37.
And what's the sister's name?
Her name is Shanteria Hamilton.
Can you spell that for me? Shantelia.
Shanteria sounds like.
H-A-N-T-I. I really can't spell it all the way out. I'm sorry. I'm not gonna lie.
Okay. Well, is your mother willing? Somebody's gonna have to sign you out since you're only 17.
Yes, I had called my mother recently and she told me whatever y'all tell, like whatever if she need to sign, she will come up here and sign it.
And your mother's name is Kimberly Hamilton?
Yes, ma'am. Yes, sir.
Okay. All right, so Ms. McLeod, I'm gonna give her a signature bond through pretrial, a $2,000 signature bond through pretrial. She is going to have her mother sign her out. Her mother's gonna have to bring a utility bill or form of identification with her. 1 day anger awareness, no further contact with GALA Hamilton, and no drugs, alcohol, or weapons while out on bond.
Thank you, Honor. I'll just get in touch with her mom to let her know what she needs to do.
You said Kimberly Hamilton?
That's
Yes.
what she said. I assume that's KIMBERLY. Okay.
Make sure her mother have a valid ID too.
Okay, I'll do that.
All right. Good luck to you, Ms. Hamilton.
Thank you, Honor.
Who do we have next?
Position number 2, Ms. Cornelius Harrington.
Good afternoon, Ms. Cornelius Harrington. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Can you repeat it? I'm sorry.
Yes, we're doing this by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 22 CR 008016G with battery. Ms. Sauer, is there any additional facts that you'd like to go into?
Yes, Your Honor. Just for the record, I would like to state that this was not a dual arrest. This was just the two defendants, the two co-defendants were the only parties arrested. And the state is requesting a $3,000 surety bond, no contact with the victim, no contact with the co-defendant, stay away, 1 day anger awareness, and no drugs, alcohol, or weapons.
Okay, and it's my understanding that this is her first arrest also. Ms. Gant, who is your client, Cornelius Harrington, to Opry Hamilton?
They, I guess, appear to be friends. I inquired more about her relationship with Miss Hamilton, Gayla, whom she does not know.
Okay. Go ahead, Ms. Gant.
Thank you, Your Honor. Christy Cornelius Harrington is 20 years old. She has been in the Atlanta, Georgia area since May of 2022. She relocated here from Oklahoma City. She does have family here, including a grandmother. She graduated from high school. She was working, but she is now unemployed and has been so for 1 month. She strongly denies the allegation. She does not have anyone to assist her with bond. This is her first arrest, and I am requesting a signature bond on Miss Cornelius Harrington's behalf. We are opposed to the stay away. As I understand it, this is a state capitol building. I would ask that Miss Cornelius Harrington be permitted to return there if she's on official business. And we are unopposed to any orders to stay away from Miss Hamilton, the co-defendant.
Okay, it's going to be a $3,000 signature bond through pretrial, 1 day anger awareness, no further contact with Gayla Hamilton, stay away from the state capitol unless she has official business there, and no drugs, alcohol, or weapons while out on bond. Good luck to you, ma'am.
Thank you, Your Honor.
Who do you have next?
John Pimple, position number 4.
Good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you, ma'am. You've been charged in case 22 CR 008018B with false report of a crime. I'm told by pretrial that this is the first arrest. Ms. Sari?
Yes, Your Honor. The state will consent to a $3,000 signature bond through pretrial, no contact with the victim, who right now we only have the last name as Bennett. no drugs, alcohol, or weapons. Your Honor, briefly, the facts of this case is that at 6940 Roswell Road, officers responded to this incident location because the defendant had called over 7 times in the past month in an attempt to remove the victim from the home. They informed her of the proper way to evict someone, but she ignored those protocols. And on this date, she called 911 to report that her door was kicked in by the victim and he threatened her with a knife. When officers arrived, the defendant was hanging out of a window. The officer assisted her down and brought her back in the house and asked what happened. She told 2 different accounts of the story. The first story was that after the police left, on an earlier call, the victim threatened to kill her, their unborn child, and himself. And then she said she was inside the bedroom with the door closed when she heard the victim going to the kitchen to retrieve a knife, and that he ran upstairs and stabbed the door. She claimed that she then tried to exit the window. The second story was that she saw the victim, run upstairs waving a knife. So that's 2 different accounts of the story. The victim actually stated that he and the defendant got into an argument and he banged on the door, but there was no knife. And after reviewing the crime scene, speaking with the victim and speaking with dispatch, the officer found that the defendant was making up the story in order to rush the police over to remove the victim. So we will consent to a $3,000 signature bond as this is her first arrest, no contact, and no drugs, alcohol, or weapons.
Any objection to any of that, Ms. Gant?
No, Your Honor, but we would ask for third-party transfer. My client informs me that she is 7 months pregnant and the child's father is Mr. Bennett, the complaining witness.
Do you have a first name for Mr. Bennett?
It was difficult for me to read, but I have Faheem as the first name and the last name Bennett.
All right, Faheem Bennett. All right, so it's $3,000 signature bond through pretrial. No further contact with Mr. Bennett. Third-party transfer of the child, and no drugs, alcohol, weapons while out on bond. Is that sufficient for everyone?
Yes, it is. Thank you, Your Honor.
I have a question.
Yes, ma'am.
Will they explain like what the
who's speaking? Who's speaking?
You can talk to Ms. Gant at a later time, ma'am, if you need to have any questions answered. I thought she might have some question, Ms. Gant, regarding the child issue.
No, not the child. I was saying
I'm happy to give you a call, Ms. Dalrymple. I'm happy to give you a call.
Thank you.
Thank you, Your Honor.
Okay, we have next.
Position number 5, Ms. Faison. Ladies, no talking, please. Thank you.
Good afternoon, Ms. Faison. I'm Judge Eric Moore. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
I do.
Thank you. You've been charged in case 22 CR 008011C with battery family violence. Is there a history, Mr. Howard?
6 total. Last arrest was 2020. Trespass damage. 2020 FTA for ag assault. 2019 obstruction. 2019 ag assault. She was on probation for that. 19 SC 172917. In 2020, they gave her 10 years probation.
Yes, Your Honor. This incident took place at 875 Conley Road in Atlanta. Officers responded to the incident location regarding a dispute. The victim in this case, whose name is Shanda, that's Chanda, last name Taylor, common spelling. She stated that she had just arrived home when the defendant, who is her daughter, came out of nowhere and started to talk with her in the parking lot. She stated that the conversation started out cordial, but then the defendant grabbed her by her wig, pulled it off, and started to punch her in the head. And the victim was able to fight off the defendant, but the defendant said she would be back to get her. In this report, Your Honor, this officer did notate that he was familiar with the violence between the defendant and the victim. He stated that the victim has temporary custody of the defendant's child through a defects order. And in the past, the victim stated she tried to help the defendant get her child back, but the defendant wouldn't comply with those programs. And the officer also stated that he came out on the call regarding the temporary custody, and he informed the defendant that she was not allowed on the property and to not have any contact with the victim or the child. So she has violated that by picking up this case. Due to her history, Your Honor, that ag assault from 2019, she was given a little over 9 years of probation. She has violated that. There was a different victim in that case, the 2020 FTA. She presents a risk of flight. And also in 2020, the criminal damage to property, that was against her mother, the very same victim here today. That was a conviction. She threw a brick through her mother's car window, causing it to shatter. Also, when I looked into that case, Your Honor, there was a signed order stating that the defendant did not comply with probation. So she not only is a violent offender, she presents a risk of reoffending and intimidating the victim. The state is recommending a $4,000 surety bond, no contact with the victim, stay away, 1-day anger awareness, and no drugs, alcohol, or weapons.
Ms. Gant?
Thank you, Your Honor. Ms. Shaniqua Faison is 26 years old. She has been in the Atlanta, Georgia area for 5 years. She does have family here, including a significant other, and she has 2 children, ages 3 and 3 months. And Ms. Faison informs me that her children are no longer in her mother's custody, Your Honor. Ms. Faison graduated from high school. She is self-employed as a hairstylist, although she states that that business is not profitable. She does not have the means to pay much, if anything, toward bond. I am requesting a signature bond on Ms. Faison's behalf. I do acknowledge her history. However, Your Honor, her last contact with law enforcement was in 2020. The FTA, I believe, is remote. So we are requesting a signature bond. If Your Honor determines that she is ineligible, then I would ask for a bond of no more than $1,000 for the battery family violence. We are unopposed to the no contact and stay away orders. And if Your Honor orders a surety bond, we are opposed to the 1-day anger awareness, that she will not be able to afford that. Thank you, Your Honor.
It's going to be a $1,500 good bond. No further contact with Ms. Taylor. Stay away from the Conley Road address. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Faison.
Thank you.
Thank you, Your Honor.
Thanks, Your Honor.
Right, thank you very much. We have one more that wasn't covered. I don't know what we did. Position number 3, Justin Curtis.
Let me call South Rice Street and find out.
Is that Justin Curtis?
Right. Hit and run and failure to obey a stop sign.
Yeah, the jail informed me that he's been in Cobb County for 300+ days for a felony charge, and they weren't able to bring him over, so he has to be reset.
So I guess tomorrow. And see
I
what
wasn't sure of the day they reset him for, but they just told me.
Your Honor, we reset him for tomorrow.
Okay, very good.
They'll
Thank
bring
you.
him tomorrow.
All right, I appreciate it.
Thank
All
you.
right. All right, thank you all. So let's see. Whenever you're ready, Ms. Bridgewater, we can go over the calendar.
Excuse me, if I may, Your Honor, when Ms. Bridgewater is reviewing the calendar, may she state the bond and conditions for position 10, Love?
I will.
Thank you.
You're welcome. Okay, once again, the reset date for the SAP calendar is going to be December. December the 13th. Okay, position number 1 is a $3,000 SOB through the jail, and it is reset further notice. Position 2 is reset further notice with a $3,000 SOB through pretrial. Position 3 is going to be reset till tomorrow. Position 4 is reset further notice with a $3,000 SOB through pretrial. Position 5 is going to the SAP calendar with a $1,500 good bond. Position 6 is reset further notice with a $3,000 SOB through pretrial. Position 7 reset further notice with a $2,000 SOB through pretrial. Position 8 reset further notice with a $3,000 SOB through the jail. Position 9 is reset further notice with a total $4,000 SOB through the jail. Position 10 is reset to the SAP calendar with a $1,500 total good bond. No further contact with Francis Ray to stay away from the 4885 Lockerbie Drive. No weapons, drugs, or alcohol. Is that what you were looking for, Ms. Gant? Okay. Position 11 reset to the SAP calendar with a $1,500 total good bond. Position 12 is going to the SAP calendar with a $1,000 total good bond. Position 13 going to the SAP calendar with a $2,500 total good bond. Moving on to the add-on calendar, position number 1 is reset to the SAP calendar with a $2,000 good bond. Position 2 SAP calendar with a $1,000 good bond. And position 3 reset further notice with a $5,000 SOB through the jail. Are there any questions, comments, or otherwise?
Yeah, number 9 was 5,000 jail. I mean 4,000.
4,500 on each charge, I believe it was.
And what was number 5?
Number 5 was reset to the SAP calendar with a $1,500 good bond.
Thank you, ma'am.
Okay. Are there any others?
Judge, you on for tomorrow?
I am not. Work that's on tomorrow for me, so